Hello and good afternoon. This is Kimberly, and I know I am not Dr. Asekun. He is currently in court proceedings, so he will be joining us shortly. He just wanted me to go ahead and start. So I wanted to go ahead and start by saying welcome. I know that we have been gone for the last 2 weeks. So, as some of you may know, Dr. Asekun actually traveled. He was in Nigeria because with the Olu and Simi Asekun Foundation, when they donated the Dr. Olusegun Asekun Law Resource Center, they actually went ahead in 2024 and started an annual moot court competition that is held in Dr. Asekun's honor. So, of course, he had to be there. So, he has been in Nigeria for the last 2 weeks. And I know that if some of you are familiar with our channel, then you may be familiar with my face. But unfortunately, I was assisting on court cases the last 2 weeks. So, I was unable to assist as well. So we really appreciate your patience. And I know we've gotten a lot of calls and texts and emails. Where's the podcast? Is everything okay? And we do apologize for, the time that we were away. But we are back now. So again, good afternoon. My name is Kimberly. I'm a paralegal here at the Law Office of Olu Asekun, and Dr. Asekun will be joining us shortly. He just wanted me to go ahead and get started with some of these immigration updates, and then as soon as he's finished with the court hearing, he'll be joining us. So thank you again for joining us, and be sure to follow us on all of our social media. We have Instagram, TikTok, YouTube, and Facebook. Am I missing one? X, yes, X. So, okay, there you are now on the screen. So go ahead, make sure that you're following us on all of those platforms. And then if you want to go ahead and book an appointment with our office, then you can go ahead and call our law office number. That is different from the number that is up on the screen over here. The number that's on the screen right here, there we go. This number is just for our podcast. This number is just for people to send questions that they want us to answer during the podcast. We don't respond when it's not the podcast time and it's not a phone that's monitored. So if you want to book an appointment to have a consultation with the attorney, then you can do so by visiting our website, or you can call our main office number and press 1 for reception. And there was one other update I wanted to say. Well, when I think of it, I'll come back to it. So, all right. Oh, yes. Okay. The other update that I wanted to state. So, as we've mentioned previously, there have been some court cases that have been reopened. They are cases that were administratively closed previously, maybe during the Biden administration, maybe even before. So these cases that are being reopened by DHS, it's really important that if you had an attorney, that attorney has your updated contact information. And then the same goes with the court. It's really important to make sure that you've been doing the change of address forms with the court, even if your case was administratively closed. I'm not saying for cases that were dismissed or terminated. Right now, it's cases that were administratively closed with the court. Make sure that you are updating your address with the court. And also, if you had an attorney, make sure that that attorney has your updated phone number, your updated email address, and also your updated physical address or mailing address. This is really important because we actually just received a case. I believed it was administratively closed in 2016, I want to say. So it's really important to ensure that your attorney knows how to contact you if your court case gets reopened. So that's just an update that I wanted to bring up and bring to everyone's attention. They're saying the voice seems to be a bit low. Here, let me scoot up a little bit.
I should increase the volume.
Oh, okay. Okay, thank you. Okay. So let me go ahead and get into these updates that Dr. Asekun wanted me to get started with. So it's not even just this week. It's from June 2nd to June 16th. These are the updates in between those times. So the times that we've been away. So the first update is the Secretary of State, Marco Rubio, has instructed all U.S. embassies worldwide to pause scheduling of F, M, and J visa interview appointments. So it looks like they're pausing mainly the student visas and M. What's M? Okay. So if you are looking to come here for school abroad, it looks like worldwide they are pausing all of the visa interview appointments. Okay. So M is for vocational programs and non-academic ones as well. So if you are currently seeking an F, an M, or a J visa, just know that they are pausing all of the visa interview appointments. So if you have an attorney, maybe contact them or just make sure that you're keeping up to date with it and checking your account. But if you haven't received an interview, that is probably why, because they have paused all of the visa interviews for those categories. Oh yeah, no, just for consular processing. Yeah, because it said embassies worldwide. Yes, sorry. That's a good clarification. So that's not for people who are here currently. Those are for people who are applying from abroad and doing consular processing to come into the United States already with their visa for those categories. Okay, and then the next update, the Department of State is developing new social media vetting guidelines for visa interview appointments. So this is a very important thing as well, to make sure that when you're applying for any type of benefit with USCIS or just any type of immigration process, make sure that you're being mindful about what you're posting on social media, because they're getting, as social media becomes more prevalent in our society, obviously immigration is going to see that and they're going to try and use that to their advantage. So it's really important to be mindful about what you're posting, especially with the political climate right now. It is very important just to be mindful anytime that you post anything to any of your social media accounts, because if I were in this situation, everything that I would post, I would be posting it with the mindset that they're going to see it, because there's a good chance that they will. Because if they're beginning these new social media vetting programs and guidelines, then it's really important. So if you're applying based on a spouse, if your spouse is applying for or petitioning for you, and then your social media says single, that's going to be a problem. If you're trying to tell immigration that, oh, I am married, but then your Facebook says that you're single, that's going to raise some red flags, especially if you're an avid social media user. And then also be mindful of all the photos that you're posting, or just steer clear of anything political. Don't be posting about things that could either raise a red flag or be seen as a political reason for them to deny you entry. Okay, so the next update is TPS for Cameroon terminates effective August 3rd, 2025. So this is very important for anyone who is currently on TPS for Cameroon. You will need to either contact your immigration attorney or try and figure out another type of relief for you to seek or some other way to keep yourself in status. Because effective August 3rd, 2025, TPS, which is the temporary protective status, is going to be terminated for Cameroon. Okay. And then the next update. DHS is ramping up review of immigration records so as to take immediate action to enforce visa overstays. So it looks like the Department of Homeland Security is going to really be reviewing all of their records to enforce visa overstays. So anyone who has overstayed their I-94, this is a very important distinction. There's a difference between an I-94 and your actual visa. So what's really important is the I-94. The I-94 is what actually gives you your legal stay. You may have a visa that is effective for 2 years, let's say, that says that it's valid from 2025 to 2027. What's more important is the I-94. That's what you get when you actually enter into the country. The I-94, it's typically, say you're coming in on a visiting visa, it's typically about 6 months. So you really need to be mindful of that date that expires and really be sure to, number one, if you are planning on staying, contact an immigration attorney or see what other options you have to stay in the country, because your case becomes a lot more complicated when an overstay is in your record. And then now that DHS is going to do a review of all of their records in order to try and enforce that visa overstay, this is also important because depending on the type of application or the type of relief that you intend on seeking, you can't overstay. So say that you're applying for anything employment-based. You have to be in status and lawfully present the entire time that you're here. So from the moment that you entered the country, you need to be in status and lawfully present. So it's really important to pay attention to the I-94 so that you don't overstay. And then even some family-based categories, it can actually be, it can work against you if you overstay, and you can actually become ineligible based on this. So say for a sibling petition, you need to have been in status the whole time that you've been here. So being mindful of that date is very important. And if you've already overstayed and you don't currently have a legal immigration status, then right now is the time to really visit an immigration attorney, check out all of your options and see what's available to you. Because right now with the political climate, it's very, very important to try and make sure that you have some type of legal status or some type of relief from removal, because heaven forbid you happen to come across an ICE officer and they end up detaining you, you need to be sure that you have some type of relief from removal. So it's really important to visit an immigration attorney and then even see what your options are and then listen to the attorney. If they're giving you, options, make sure that you're following the instructions and taking it very seriously. because we have so many people come to us very scared and very nervous, but then they don't seem to take the case seriously. And we'll ask for things and then it'll take a while to get them back or whatever it may be. Just take your own case into your own hands and take it very seriously. Okay, the next update. Okay. Warning letters are being issued to some lawyers by EOIR Office of Fraud and Abuse Prevention. This is to warn lawyers who are perceived to engage in fraudulent practices. So EOIR, that's the Immigration Court. It's the Executive Office for Immigration Review. So they are issuing some lawyers warning letters if they are perceived to have been engaging in fraudulent practices. Okay. The next update is the OPLA, that's the Office of the Principal Legal Advisor. So that's the government's attorney when it comes to immigration court. That's like the DHS attorneys. The OPLA is requesting immigration judges to terminate some removal proceedings. ICE would therefore arrest, detain, and remove these aliens on the ground that they no longer have any pending case. This is something that I'm sure everyone who's watching this has heard it in the news, that people are going to their immigration court proceedings, that they'll have a hearing. And let's say, for example, their current relief, the application that they intend on seeking, is asylum, just for this example. So they will go to their scheduled hearing. Let's say it's a master hearing, the first hearing that they're going to. And the government's attorney will say, we no longer wish to pursue this case. We would like this case to be terminated. We'd like it to be dismissed. And then the judge may grant it. Some people are thinking that this is a good thing. They're thinking, oh, I'm no longer going to have to come to immigration court. I'm not going to be in removal proceedings anymore. However, they are having plainclothes ICE officers near the courtroom waiting for those people. They'll know what they look like, and then they will come after them and arrest and detain them because they no longer have any relief from removal. If you have a case such as an asylum case, and then it gets dismissed with the immigration court, who is the one that currently has jurisdiction, then there's no longer an asylum case pending. Therefore, they can now remove you, they can now detain you and remove you from the country. And it is becoming very scary. A lot of people are being detained right now. So anyone who has any immigration court proceedings, please, I know I keep saying be mindful, but I feel like it's the best term that I have for today. Just be mindful of that. And if you can go with an immigration attorney, then go ahead and do so. If for any reason you can't go with an immigration attorney and you do need to go on your own, then there's a couple of different things that you can do. You can request for them to issue a written request to terminate the proceedings, because then that will give you 15 days to respond to that. So that's an option that you could pursue. Or you can try and say that you don't agree. That's not necessarily going to mean that they won't do it, but try and say that you do not agree, you don't want your case to be dismissed, and then ask for a written request or a written motion for them to go ahead and terminate the proceedings to allow you 15 days to respond to that. So that's an option that you have, but just be sure, a lot of people think that getting their case dismissed is a good thing, and in some cases it may be, because in some cases it can lead to immigration having jurisdiction over your adjustment of status application. However, you need to be sure of what is specific to your case. So definitely be aware of that. And if you do have an active relief, then a lot of people, there are plenty of people who don't have anything to worry about. I don't want to try and fearmonger anybody, but just be aware of it. Be very aware that this is happening and be informed of what's going on, just to give you some sort of peace of mind when you're going in. Okay, the next update. EOIR leadership. So EOIR, again, that's the Immigration Court. That's the Executive Office for Immigration Review. EOIR leadership has issued guidance to immigration judges on how to handle these dismissal requests. And then we have not been able to see it yet, but Dr. Asekun wanted me to let you all know that as soon as we see the guidance, then we will go ahead and share it with our listeners. And then the next update. Exceptions granted to farms and hotels from immigration raids have been reversed by ICE following pressure from the White House. So I know that President Trump had stated previously that he was no longer going to be pursuing anybody on farms or any type of agricultural work, that he was not going to pursue those or hotels, and that those were going to be, for the time being, safe from immigration raids. However, it looks like he has regretted saying that, and now he has reversed that decision. So the previous decision to stop the raids on farms and hotels, that's now been reversed, and they will begin doing those raids again. Okay. And then the next update is President Trump is considering adding another 36 countries, including Nigeria, to the travel ban. No decision has been taken yet on this, but it is currently being considered. Countries affected have been given 60 days to address U.S. concerns. If they do, they will be taken off the list. So this is another thing that's been in the news a lot. So just be sure to keep updated. As soon as we hear if for sure those countries are being added to the travel ban, we will of course let you know. But as of right now, Nigeria has not been added, but they are considering it. So just, again, that's another thing to pay attention to and try and be aware of. And those are all of the updates that he wanted me to share. Do we have any idea? Oh. With a WebEx. Oh, go. Oh, okay. Okay. Here, no, it's okay. I'll do it.
Okay,
I'm so sorry. Hold on one moment, please.
something came up.
Something came up.
We're
Well,
gonna pause it for now.
we're going to pause it for just a minute. Okay. I'm so sorry about that. We are back. The lawyer just was having an issue with the WebEx and he needed me to come quickly assist him with it. So, okay. And then he also wanted me to quickly. Oh, we are back. The lawyer just was having an issue with the WebEx. Okay. Okay, sorry about that. So he wanted me to quickly make sure that everyone's aware that he will, as soon as he comes in, he will be staying for, well past 1 p.m. today because it's already 12:36 and he has not been on, and especially because we've been gone for 2 weeks. So he said that he's going to address as many questions as he can today and that he will take more time than he has been, take more time than the typical 1 hour that we are on. So he just wanted me to make sure that everyone was aware. And then he also gave me a couple more updates. So another update is that the policy on the Form N648 has changed. So Form N648 is the medical certification of disability exceptions for Form N400. So this comes when anybody has any type of disability that needs to be recognized when taking the N400, which is the naturalization citizenship test. So typically when people take this, they will get a certification from their doctor that states why they may not be able to take the test, why they may not be able to understand certain things. I mean, this is typical for people with any type of learning disability or even in cases with dementia or Alzheimer's, things of that nature. So the policy on that form has changed. So the form has been updated and the form will now be concurrently submitted with the N400. Previously, you did have the option of submitting it later. It is always better to just submit it along with the N400. However, now you have to submit it concurrently. And then there will also be increased review and scrutiny. So it looks like they're going to be digging a little bit more into those cases, and they will be ensuring that anybody who submits that really does need the exception. So that is the update on that form. And then for those applying for visiting visa effective immediately, the DS-160 confirmation number must exactly match the number on the visa appointment notice. In addition, the form must be submitted at least 2 business days before the interview. Failure to comply will mean that the interview will be rescheduled. So this is really important for anybody planning on traveling for pleasure, anyone coming in with a B1, B2 visiting visa. So really be sure that you complete all of the required forms and submit all of the required documents and make sure that those numbers match exactly. And also be sure to submit it at least 2 business days before because you don't want the interview to be rescheduled, especially right now with the travel ban and the countries that are, being looked at. It's really important to just make sure that you get everything right and get it right the first time. Make sure that you submit everything timely so that your interview will go on as scheduled. Okay, so that is the end of the updates. So let me go ahead and go over to the live chat and see what questions we have. Anything that I can't answer, we'll go ahead and wait for Dr. Asekun to come on. But let me go ahead. Oh, okay. Yes, that's right. Okay, so the first one just says, good morning. Good morning to you as well. Thank you for tuning in. And then, okay, the next one was the voice, which I hope we fixed. And then the next one, can you move it? Sorry.
Oh, I'm so sorry.
No, it's okay.
I was looking at it on my phone. I didn't see you couldn't see.
Okay. Thank you for standing in for Dr. Asekun. Oh, you are very welcome. Thank you for tuning in. Please, under what category will I apply for citizenship with my green card I got from my son in the military who is in active service? Thank you. Hold on, I want to look at the form and see exactly if there's a specific option for you to fill. Let's see. Okay, so I'm looking at the form N400 right now, and there is an option that says at least so it would depend on which option. There are two options. There's military service during period of hostilities, and then there's also option, so that was option E on the form, and then there's option F, at least 1 year of honorable military service at any time, and that's eligibility for current and former members of the U.S. Armed Forces. Hold on. Sorry, hold on.
Maybe you want to leave it to the lawyer, but this is the. It looks like it's
No, but that's it. Oh, but okay. So I am so sorry. I am going to leave this question for the lawyer because I do not want to give you misinformation. Let me look at it, but I'm also going to go ahead and wait for the lawyer to go ahead and answer this question because he is the one that's going to be better suited to answer it. And I do not want to provide you with incorrect information. So I'm going to go ahead and flag that one for him to come back and do. Okay, so the next question. Please, as a Nigerian, can I still travel to Nigeria as a dual citizen? Yes, yeah, you can travel. Yes, just if you're saying dual citizen, I'm assuming that you mean dual citizen of the US. So just as the lawyer has mentioned previously, when you come back in, use your United States passport upon entering the United States. And then the next question. So via text. Good afternoon and welcome back. Can a felony with a 3-year probation that ends in August of this year be an issue for spouse adjustment of statuses about to start the filing process? So I would need more information. Yeah, we would need to see the disposition of the case, the charges filed, and then are you saying that it be an issue for spouse adjustment of status? Are you saying that you are the one with the felony conviction, or is it your spouse that has it? Because it could be an issue, and it could be something that you would need to file a waiver for, but unfortunately we would need more information for this. We would need to see the disposition of the case and see exactly what was stated, and we would need to see exactly what the charges were. And again, it would depend on which one of you is the one with the felony conviction. So unfortunately, with more information, that's not something that I can answer at this time. Okay. Good afternoon, Dr. Olu Asekun. Again, I apologize. He'll be here shortly. I came into America 2019 with my wife and applied for asylum, which is still pending till date. How can my elder sister, who is a U.S. citizen, file for my 9-year son? So your sister cannot file for your son. There's not a way for a sibling to file for your child. And so sorry. So when you applied for asylum, were the children not included?
He didn't say that.
No, it doesn't say. So essentially, your elder sister cannot file for your son. There's not a provision for an aunt or an uncle to file for their niece or nephew. So unfortunately, that's not an option. Oh, hold on one second.
I think we are going to switch.
Okay.
If the judge comes in, then you just call.
And then you'll call.
Oh, okay.
Yeah.
Okay.
I can't just sit down there and just waste.
Okay. So Dr. Asekun and I are going to switch. I'm going to go watch his case, and as soon as it comes up, I'll come and get him, but he's going to be joining us right now. Okay. Thank you.
I have the thing open there. Good afternoon, ladies and gentlemen. Apology for the mix-up this morning. I have a case at the immigration court. The case was supposed to be WebEx. I've been waiting in front of the computer for almost 3 hours now. The judge has not come up. So I'm just going to go ahead and join the podcast because I realized that time is fast going. It's almost 1 p.m. and I'm still waiting for the judge to come on. So I will just continue. Again, I want to apologize for the couple of weeks I traveled out of the country. I've not been around. But we are back now. Thank you again for your patience. Thank you for all the messages. Some people thought I probably got into trouble with the government. No, I actually traveled out of the country. So everything is in order. Thank you again for the concern. Some people sent in gifts. I came back with a lot of messages, goodwill messages, gift for my 68th and all of that. I just want to appreciate everyone. Thank you again. Now, let's continue. I know that...
We're ready with the questions. I don't know if you want to go over any of that.
Let's go with the questions for now, because time is fast spent. At least next week, by God's grace, we'll go over the updates. I believe that Kim has mentioned some of them. Okay.
Now, this one, we left some questions out because we prefer you to address them.
Yeah, let's go back to any question that has been left out.
Okay, that's the first one right there.
Okay. Thank you for sending it. Oh, okay. This is just a comment. It's not a question. Oh, is it?
No, it is.
Okay. Thank you for standing in, Dr. Asekun. Please, under what category will I apply for citizenship with my green card? I got from my son in the military who is still in active service. Okay, if your son is in active service, what's that? Is it the same question?
Yeah, it's part of it.
Is it it's not showing here?
No. It wants to know what category to use.
Oh, okay.
Kim checked the form, but she couldn't address it, so she left it to you.
Okay, yeah, that's not a big problem. If your son is in active military duty, you will be eligible for citizenship within 1 day of becoming a permanent resident. So in other words, if you already have your green card and your son has been in active military, then you'll be eligible to apply for citizenship after 1 day of being a permanent resident. The requirement is that your son must have been in active military for at least a year. And of course, when you apply in the cover letter, I suggest that you use an immigration attorney who probably will be able to help you. In the cover letter, that's where you will state the section of the law that permits you to apply within the military. In the N400 itself, I believe there are two options regarding military members. But usually what we do is the cover letter is the one that will state the category so that they know that you are applying as a active military family member. So that is the cover letter that will indicate that. I will also show the section of the law that permits that. So it's not a special problem. Next question, please. Please, as a Nigerian, can I still travel to Nigeria as a dual citizen? Oh, yes. I just came back from Nigeria yesterday, so you can still travel as a dual citizen. I traveled to Nigeria with my Nigerian passport, and I came back to the US with my American passport. Yes, it can still. And to be honest with you, there was no question asked. In fact, we didn't talk to CBP officer on arrival. We just faced the computer took a picture, and we walk in. That's it. Yes, you can still travel.
Can they travel if they have any criminal record or any ongoing?
A U.S. citizen is a U.S. citizen. Whether you have criminal record or not does not affect travel. If you commit a crime as a U.S. citizen, you get penalized for whatever they do for people who commit crime. That's what they will do. If they need to jail you, they jail you, but it doesn't affect travel. The only time criminal activities affect travel is if you commit a crime that impacts your American passport. For example, I know of some people who are convicted of tax-related offenses, and of course, they withdrew their American passport. You see, having a passport is a privilege, it's not a right. So there are some criminal activities that can lead you to losing that privilege. But of course, not that you have a valid passport and you are prevented from traveling. No, you cannot be prevented from traveling as a U.S. citizen if you have a valid passport. But if you commit an offense that warrants the withdrawal of your passport, of course, they will seize the passport from you, so you will not have the physical passport to be able to travel. Next question, please. I want to move as fast as possible. Okay, good morning and welcome back, doctor. Thank you. Can a felony with a 3-year probation that ends in August of this year be an issue for spouse adjustment of status about to start the filing process? This question is not very clear. Who has the felony? Is it the petitioner or the spouse? Or is he asking the question on behalf of the spouse? Because the answer will depend on who is affected. Okay, I'm going to answer it both ways. Assuming that the petitioner is the one that has the felony, it will be an issue if the felony is child-related offenses, Adam Walsh Act offenses. criminal activities involving children, pornography, sexual molestation of a minor, child trafficking, child pornography, generally offenses against children. Even if you are a U.S. citizen, even if you are the petitioner, will it affect you? Yes, it will affect and impact your ability to petition for your spouse. That is assuming that you are the petitioner. Now, assuming that you are the beneficiary, yes, it will also impact it, but it depends on the nature of the felony. From this fact, this person has already been placed on 3-year probation. So I'm assuming that that is the outcome of the case. So, of course, any offense that warrants 3-year probation for immigration purpose is considered aggravated felony offense. Again, it depends on the nature of the offense. Some offenses, you may still be able to apply for a waiver of criminal ground of inadmissibility, but it is not every offense that can be waived. So I will still need to know more about the offense. But generally, if this is the beneficiary, you will need a waiver. Will it impact your petition? Yes, you will need a waiver. If this is the petitioner, it may affect it, it may not affect it. It depends on the nature of the offense. If the offense is child-related offenses, yes, it will affect it. If it is not, it will not have anything to do with it. Next question, please. Good afternoon, Dr. Olu Asekun. I came into America 2019 with my wife and applied for asylum, which is still pending till date. Please, how can my elder sister, who is a U.S. citizen, file for my 9-year-old son? Unfortunately, there is no provision for that under the American immigration system. First and foremost, even you and your sister, for immigration purpose, you are not considered a member of the same family. You are considered extended family member. And currently, waiting period for sibling petition is about 16, 17 years. That's the waiting period. But then, even at that, your sister cannot petition for your own son because your sister and your son, there is no provision for that kind of relationship under the immigration law. However, since your son is still a 9-year-old, and even though the fact pattern is not very clear, but I'm assuming that your son is here in the United States. Assuming that my assumption is true, your son is physically here in the United States, your sister can do one of two things. One, your sister can adopt your son, but again, the adoption will have to be carefully done because immigration is they always frown at adoption that are specifically carried out for the purpose of getting immigration benefit. They don't like that. So you will have to show that the adoption is proper. The adoption was not carried out just because you want your son to be able to have legal status. But assuming that to follow the right procedure, if your sister adopted your child, then your sister may be able to petition for that child. The other thing that your sister may be able to do, that one is a SIJ. But the problem with that, again, is that SIJ will require your sister showing that it is not in the best interest of your son to be with you. So either because you are abusing the son, or you neglected the son, or you do something. You see, this is a very delicate area because you don't want to, in the process of trying to get immigration status for your son, you don't want to put yourself at risk again, because if you are here and you are also showing that either you are abusing your son, or you have neglected your son, or that it is not going to be in the best interest of your son to live with you, that speaks something about you. So I don't know the impact that will have on you. those kind of arrangement is better done with somebody who is not here in the United States, so that at least they don't see you as being careless. Because come to think of it, assuming you are the immigration officer, if you can show that this man is not fit to take care of his son or his child, so why will you want to get benefit? Because I'm sure you yourself, based on this fact, you file an asylum and you want them to approve your asylum. So it's really it's really a very tough situation. It's not an ideal situation. But generally, your sister cannot petition for your son. There is no provision for that under the Immigration and Nationality Act in the United States. Next question. Hello, if a case was administratively closed, but you have received your green card since then, are you at risk of that case being reopened and at risk of getting the green card revoked? Yes, especially if the green card was issued without jurisdiction. You see, there's a difference between a case that is administratively closed and a case that is terminated. If a case is terminated, USCIS retains jurisdiction. They retain authority over green card application. So they can grant you green card. So if your green card was granted, nothing can happen to it because of the case. On the other hand, if a case is administratively closed, USCIS will still not have authority. They will still not have jurisdiction over your green card application. So what that means is that if your green card was approved by USCIS when you have a case that was administratively closed, so that means that the green card was approved without authority. USCIS does not have authority to approve the green card. There are two exceptions to this. This is not, I always say that immigration is not a one-cap-fits-all. There are two exceptions to that. Number one, arriving alien. Anyone who entered the United States as an arriving alien, both immigration and the court, they have concurrent jurisdiction over green card application. So both of them have concurrent jurisdiction over green card application. So if your case is administratively closed and you enter the United States as an arriving alien, and then USCIS decided to approve your green card application, yes, that green card will be approved with authority of the USCIS. So, but in either case, whether the USCIS has jurisdiction or whether they don't have jurisdiction, if your green card was approved and your case in removal proceedings was administratively closed, what you need to do is to file a motion to reopen and terminate. So you file a motion with the immigration court to reopen your case and then ask them to terminate the case by showing evidence that you are now a permanent resident of the United States. So you can do that. But before you do it, make sure that the green card was not obtained without authority, because if it was, then the judge may reopen the case and refuse to terminate it, in which case you may need to go back to reapply for your green card. So again, everything depends on the details and the fact of each case. Next question, please. Hi, everyone. Thank you for your work. Case was referred from USCIS to court. During hearing, IJ requested me to process biometric for my son and adjourn the case till the end of June. Go on. Is that a part two? Okay. For that reason, I have contacted the USCIS on phone more than approximately 15 times. They do pick calls and raise service number, but all to no avail. My lawyer said his firm no longer helps in biometric appointment issues. Please, what best way is there to secure biometric appointment for 15-year-old boy? Thank you. Well, it's unfortunate that you have a lawyer who is not willing to help you. I really don't know why the lawyer cannot help you. The truth of the matter is that calling USCIS for biometrics is not going to solve the problem. USCIS is not going to handle your biometrics if you are in removal proceedings. That is not their job. There is a way to handle biometrics for removal proceedings. Like I said, this is something that your lawyer should help you to do, because I don't even know what to tell you, because we help our own clients to set up an appointment, arrange the biometrics, and then there's a way that you will do it. You schedule an appointment with the FBI, you pay their fee, and then you go to the United States Postal Service, and where you have your son. They will take his biometrics, sent to FBI, and then the biometric information will be out within 24 hours after that. Again, your lawyer is the one that should help you with this. USCIS does not handle this, so calling USCIS, even if you call them 1,000 times, you are not going to get any result, because it is not what they do. That's not their job. So I don't know how to help you. Maybe you go back to your lawyer, or maybe later you can call our office if you need help. We may be able to. Of course, we are not going to do that for free if we are going to help you, because if you have a lawyer and you pay your lawyer, that should be your lawyer's job. So if they are not doing their job, I don't know what to tell you about that. But the only thing I can tell you is that USCIS will not do that. That is not their job. When you are in removal proceedings, you are no longer under the jurisdiction of USCIS. Removal proceedings is conducted by Department of Justice, Executive Office of Immigration Review, EOIR. They are not part of the DHS. They are not part of the Department of Homeland Security. So USCIS does not handle anything that concerns the court. So you have to, with the assistance of your lawyer, have to do that. If you are going to call anyone at all, you should be calling the ICE lawyers, the government lawyers. They are the ones that can help if you need help from them. But again, as I said, we don't even call anyone. Your lawyer is supposed to arrange that appointment for you. The judge is ready. Sorry, I have to take off, please. Can you?
Okay. Hi, everyone. As you can see, the lawyer had to leave for the WebEx hearing that he was attending. The judge is now ready to conduct the hearing. Therefore, he had to leave unexpectedly. If you want to bear with us, feel free to stay put. He should be done with the hearing pretty soon, so he can address the rest of the questions that are on the chat. Thank you so much for your patience.
Sorry.
Go ahead. Go ahead.
Again, I apologize to my listeners. This immigration court system is really something else. I waited the whole day, the entire day, just for 2 minutes conversation with the judge. I've been waiting. Now the judge came in. We had did I live up to 2 minutes? No. Probably 1 minute.
30 seconds.
1 minute conversation with the judge and the case is over.
I just finished the announcement and you came in.
Well, yeah, at least I know that case is resolved. We can now continue with our questions.
Yes.
Yeah. I now know that at least there will be no more interruption for today.
Yes, correct.
Until the end of the program. As I promised earlier, I know it's already past 1:00, but I'm going to try as soon as much as possible to attend to as many questions as possible today because of all the interruptions and all of that. I believe I was answering a question before the interruption. Okay, yeah, that was about biometric appointment. I think I was already done with that. Okay. Okay, thank you again. The next question. My wife, who is a U.S. citizen, filed for my children who are in Nigeria since January 2023. The I-130 has been pending since then. What's the implication if I sue USCIS? Well, first and foremost, you cannot even sue USCIS because based on this fact, you are not a US citizen. So you will not have the authority to sue USCIS. If you are going to sue USCIS, the only one that can do it is your spouse, who is a US citizen. But again, whether your spouse will be successful is completely different thing, because before you can go to court to sue immigration on any delayed case, you have to show that you have exhausted administrative procedures. You have exhausted all administrative avenues. Going to court is usually the last thing. That's the last hurdle. So number one, how have you submitted service request? How many times have you done service request? Number two, where is your I-130 pending? Is it within processing time or is it outside processing time? Because I can tell you there are some service centers like the National Benefit Center. The last time I checked, I've not checked recently, but the last time I checked, their processing time was about 48 months. Can you please check the current processing time for National Benefit Center? US citizen petitioning for immediate family. The last time I checked, the processing time was 48 months. 48 months, that's 4 years. So if your petition is in that particular service center and your case was filed in 2020, if you file a mandamus, the court is going to dismiss it because, USCIS will tell you that that case is still within published. Oh, 52.5. It has even increased. It's no longer 48 months. It's now 52.5 months. Correct. So that's like 4 years and 4.5 months. 4 years and 48 months is 4 years. Yeah. So 52.5 is now 4 years, 4.5 months again. So filing a lawsuit may not resolve that. So you have to, those are the kind of things you need to look into. And if I were you, I will exhaust administrative processing first. This is one of those situations where you can use congressional intervention, because filing a mandamus is not automatic. It's not that once you file it, they are going to, of course, if they have a published processing time and your case is still within the published processing time, then mandamus may not succeed. So you may want to consider that before you start thinking of filing a lawsuit. It is not in every case that a lawsuit will help. That is why we always say that immigration is not a one-cap-fits-all. Every case is different. Please, the next question, please. Good afternoon, Dr. Olu Asekun. Thanks for the great job you are doing for us here. Thank you. Appreciate it. I came into America 2019 with my wife and applied for asylum, which is still pending till date. Please move it up. Please, how can my biological sister... Oh, I already answered this. This is the 9-year-old.
This has more information. But
No, this is another one, Mr. Oh. This is part 2 of this one.
Okay, let me just read it. Okay. Thanks for the great job you are doing for... I came into America 2019 with my wife and applied for asylum, which is still pending. Please, how can my biological sister, who is a U.S. citizen, file for my 9-year-old son?
Mm-hmm. She sent it by text and she posted it on the...
Yeah, I've already answered that question.
Okay.
Can you go to...
Okay, but she put more information on it.
Okay, will file for a change of lower it. Okay. My wife graduated last year. Okay. Let me go back. Please, how can my biological sister, who is a U.S. citizen, file for my 9-year-old son? I left Nigeria since 2019.
I left in Nigeria. She left the son in Nigeria.
Oh, the son is not even here. Oh, okay. Yeah, that's not even going to be possible. Even the adoption or SID option will not even work if the child is not here. My wife graduated last year with RN nursing but could not get agency that we filed for a change of status through employment based because we stayed more than 6 months before we applied for asylum. What is your advice for us? Thanks and God bless you. Unfortunately, I really don't have a way out for you because, as I've stated several times during our podcast, when you come into the United States and you are given 6 months, you have to take a step before the expiration of that 6 months. Once the 6 months is over, you are already out of status. Whatever you do after that cannot help you when it comes to employment-based. So it is assuming you had filed the asylum before the expiration of the 6 months, yes, we may have been able to help. But in this situation, we cannot. The law is the law. We don't have control over the law. We cannot change what the law is. However, what I will tell you is that just make sure that your asylum is approvable, especially under this administration that things are really tough now. So I don't know the details of your asylum. I don't know on what basis you apply for asylum. So that is what you need to work on right now. If you don't already have a lawyer, I'm going to advise you to consult with one. Look at the viability of your asylum application. If you need to put your house in order to ensure that the asylum is approvable, that's what you need to concentrate your attention on right now. But the main thing is that, are you even eligible for asylum? Because many people apply for asylum without being eligible. There are only 3 requirements for asylum. You must show that the harm you are running away from, that harm is coming from the government of your country or coming from someone that the government is unable or unwilling to control. You have to show that the basis of the harm, the basis for which the government is trying to harm you or has harmed you, is at least one of 5 recognized grounds: race, religion, nationality, membership in a particular social group, or political opinion. And of course, the 3rd requirement is that you have to apply for asylum within 1 year of entry into the United States. So what you need to do is to ensure that your asylum case is approvable. If you have a lawyer, go and work with your lawyer so that your case you can really be prepared. It is not when they invite you for interview, you start looking for documents. This is the time to do that while you are waiting. If you don't already have a lawyer, maybe after the podcast, you can reach out to our office and schedule a consultation appointment where we can look into the specific specific details of your case and advise you accordingly. But one thing I want my listener to understand is that we can only operate within the confines of the law. Even if we are going to be creative, we can still be creative within the confines of the law. We cannot do anything outside the law. In a situation where the law says you must have ABC, if you don't have ABC, there's really not much we can do. We cannot change C to D. We cannot do that. But again, this is my advice for you. Go and ensure that before they invite you for interview, make sure you put your house in order and let your pending asylum be an approvable one. Next question, please. Sir, thank you for all that you are doing. Thank you. I am currently in Canada and have been admitted to a university in Texas. However, student visa processing has been suspended for now. I do have a valid visa to the United States. Will it be possible for me to travel to the U.S. and change my status from within the country? I do not want to lose this admission opportunity. Well, it's not that straightforward to tell you yes or no without knowing more. You see, immigration is very, very technical. As we have stated during the opening of today's podcast when we were discussing the update, one of the reasons why they suspended processing of student visa, F visa, that is student, academic student, M visa is non-academic student, vocation and all of that, and of course J visa. The one of the main reasons is because they are trying to increase the vetting, and for now they have suspended all these things. So, but as far as applying for student visa in the United States, that is still a possibility. That one has not been suspended. The only concern here is that as of today, you are still outside the United States. So if you come into the United States, there is this thin line between intent. So what are you going to tell them at the port of entry? Let's say I advise you to come in and apply for student visa in the US, which is a possibility. But the question is, at the port of entry, if they ask you, what are you coming to do in the United States? If you tell them you are coming to visit, and then you enter and then you apply for student visa, that will be construed as misrepresentation. That would be a ground of inadmissibility. That would be a ground for denial. On the other hand, I am not certain. I cannot tell you authoritatively what questions they will ask you at the port of entry, or whether they will even ask you any question at all. It is possible that you may come in and they may not ask you any question. But it is also possible that you may come in and they may ask questions. So what if they ask you questions? What are you going to tell them? If you tell them that you are coming to apply for student visa, of course, that will mean they will deny you admission. They will not allow you in because you don't have student visa coming in. So you can't tell them you are coming into the US to come and apply for student visa. That will be a no-no. On the other hand, if you tell them you are coming to visit, of course, whatever you tell them is going to be imputed in the computer. So after you come in, if you now apply for student visa, so how are you going to explain your intent at the time you enter? So those are challenges that you are going to face. Is it a surmountable problem? Yes, it is. But I just want you to know that this thing is not very clear. It's not a black and white issue, because you can get to the port of entry, and I've seen people who attempted to enter the United States from Canada and they were denied admission. In fact, I know someone who came into the US, from US went to Canada and was attempting to come back to the US from Canada and was denied admission. And this person was sent back to Nigeria. So these things are not guaranteed. So these are not the kind of questions that I can give you authoritative answer. If you are already in the US and you have admission, yes, you can change from B1, B2 to student. But in this case, because you are still outside the US, it is difficult to predict what they will ask you at the port of entry. That is why it is not really something that I can encourage you to do, because at the end of the day, what if you try it and then they ask you all these questions that will make the approval of the student visa difficult? At the end of the day, it may turn out to be a waste of effort or waste of money. So it's not something that I can guarantee. So for that reason, I will want you to reconsider your position. Next question, please. Hello, thank you for your services to educate and enlighten us. Thank you. Please, what's the implication of the proposed travel ban if enforced? 1, on citizens of the country that are already in the US. That's 1. 2, I do have a valid visa to the United States. Will it be possible for me?
Sorry, that's not part of it. This is the second part.
Okay, on those intending to come to the US. God bless you. Okay, so I'm assuming that this person is talking about the travel, the expanded travel ban. Okay, now, My understanding of the expanded travel ban is that those 60 countries, they have been given a warning. They are saying that they have been given 60 days to put their house in order. The US government has told them what the problem is, and they are giving them 60 days to fix the problem. The travel ban will only be effective if after 60 days they have not fixed the problem. Let me use the example of Nigeria. From the information we gathered from the American Immigration Lawyers Association, what they said concerning Nigeria was that they have a lot of people that they are not sure of their identity. And they don't want every Tom, Dick, and Harry to come to the United States under the guise of being a Nigerian citizen. To the best of my knowledge, I believe that this problem was raised during President Donald Trump's first term in 2017. And I also know that Nigeria has taken steps to address it, because it was after that Nigeria started enforcing NIN, National Identification Number. To the best of my knowledge, in Nigeria today, you cannot get a Nigerian passport if you don't have National Identification Number. And I also know that Nigeria also introduced BVN, Bank Verification Number. So I believe that Nigerian government is probably addressing many of these concerns. Before the introduction of the NIN, I do know that a lot of people from West African countries, they go to Nigeria, bribe the officials, and get Nigerian passport. Many of the people who commit fraud on the international scene, many of them are not Nigerians. But because it was very easy to get Nigerian passport, that's why many of these things are happening. And of course, with the introduction of NIN, I believe that it is becoming more and more difficult. I just came back from Nigeria, and I attempted to renew Nigerian passport for my daughter. While we were doing it, despite following all the rules, the passport office, they insisted that we needed to obtain certificate from our local government verifying our identity. Despite that is in addition to the NIN and all of this. So we followed those guidelines. We had to go to I'm from Ogun State, so we had to go to the Ogun State licensing office in Lagos. So we obtained the verification before we were able to renew the passport. So I believe that Nigerian government is addressing those things. But because this one is new, I've really not seen, I personally have not seen the content of exactly what the US government is asking the Nigerian government to do. But I do know that if they follow through, whatever it is that they want them to do, they probably will avoid that travel ban. But to go back to this question, how will the travel ban affect people who are already here? It cannot affect people who are already here. If you're already here, you are here. So the word travel cannot affect somebody who's already here. You're already here, so you are not traveling. How will it affect those who are outside the United States? Yes, it will affect everyone from any of those countries who are still in the United States, because they will not be able to come to the United States. Once travel ban is implemented, they will provide information to all airlines. So nobody, even if you already have your visa, you may not be able to enter the United States with a travel ban. So that's the unfortunate reality, but that's the reality.
Even if the visa was approved prior to...
Yes, even if you already have your visa and your passport, once a travel ban is enforced, you will not be able to enter the country. So, yeah. So that's in fact, I remember in 2017, during the first Donald Trump travel ban, there were people who were already in the plane at the time they announced the travel ban, and they were denied entry in the United States. It was that bad. So it will affect anyone who is still outside the country. But those who are still in the country, it will not affect them. So if you know anyone who already have their visa, and you are fearful that it may affect them, let them travel now before they before they impose it. Next question, please. Okay. Hello, Dr. Olu. Please, I want to ask the process of moving my underage sons to US after filing I-130 for them already as a US citizen. Will they become a US citizen automatically, or do I still need to file any form for them again? Well, the thing is, if your children, if they are still outside the United States, they cannot become a US citizen automatically. However, you have to file the I-130 petition for them. Once the I-130 petition is approved, they will send it to the National Visa Center. You have to apply for immigrant visa for them. You pay the immigrant visa fee, you pay the affidavit of support fee, and you follow through with the process. Submit immigrant visa application. If your children are 14 years and above, you will need to submit a police clearance certificate. If they are under 14, they may be waived. But once you finish that process, they will send it to the U.S. Embassy in your home country, and then they will attend visa interview. Upon being issued immigrant visa, you will now buy ticket for them and bring them to the United States. Once they land in the U.S., that is when they become a U.S. citizen. Immigration will not give them green card. As soon as they land in the U.S., any of them who is under 21 years old will become, who is under 18 at the time of entering to the U.S., they will become a U.S. citizen automatically. But those who are over 18, they will receive their green card and then wait until they apply for citizenship. But those who are under 18, on the day they enter the U.S., those will be automatic citizens. They will not get green card. They will get automatic citizenship. Next question, please. Hello, sir. Can one who has a denied I-485 on marriage able to apply for EB3 as a nurse? Well, we have said it over and over. In fact, I've mentioned it also today. Anything that is EB means employment-based. Anything that is EB requires that you maintain legal status. So it doesn't matter what EB it is, EB1, EB2, EB3, EB4, EB5. Anything that is EB requires that you must be maintaining legal status at all times. So the fact that I-485 was previously denied is not the issue. The issue is, are you still in status? If you are in status, yes, you can apply for EB3. But if you are out of status, any employment-based petition cannot be approved. That is the law. It's not something that we can manipulate. That's the law. The law is the law. Next question, please. Good afternoon, sir. Thanks for your advice. Please advise over 4 months. Advice over 4 months after passing citizenship interview, but request for name change to my divorced husband last name on my marriage certificate and passport, but still married to my present husband. Marriage is 7 years today and green card will be 6 years in November, but haven't had anything. Okay. I've mentioned on this podcast multiple times, whenever you apply for a change of name, swearing in for citizenship takes longer than those who are not requesting a change of name. The reason is very simple. When you apply for citizenship and your application is approved, your swearing in will be conducted by USCIS, either at their local office or at maybe a convention center or outside hall, but it will be conducted by USCIS. On the other hand, when you apply for a change of name, your swearing in is not going to be conducted by USCIS. It's going to be conducted by a district judge. It's going to be conducted by a judge of a federal district court in the jurisdiction where you apply. Now, because they have to, USCIS is in the habit of gathering a lot of people before they approach the court. They are not going to schedule one person to go to a district court for swearing in. No. So when you apply for a change of name, they approve it, they put your name on a list. When they have enough, that's when they will schedule an appointment with the district court. And then that's once the district court give them an appointment, that's when you will now get an appointment letter where they will tell you the name and address of the court where you come for swearing in. So generally, whenever you apply for a change of name, citizenship swearing in takes much longer than someone who did not apply for a legal name change. So because the fact of your question indicate that you have applied for a legal name change, so you have to be a little more patient. Generally, as far as citizenship is concerned, after the interview, immigration have 120 days, which is 4 months, to take a decision on your case. But where you have requested a legal name change, they have to wait because this is something outside their control. It is the district court judge that will give them an appointment. And they are not going to schedule an appointment for one person. They are going to gather enough people. It is only after they have enough people that they will request an appointment, and it is only after they have an appointment that they will get back to you. Okay, next question. Thanks for all you do, Dr. Asekun. What's going to be the future of people from Niger that have overstayed their visa if Niger is announced as part of travel ban country? Well, let me say this. This is even more than the travel ban. If you listen to the update today, which I believe that Kim did, part of the update today is that USCIS is actually ramping up documentation regarding visa overstays. So this is not even about the travel ban. That's one problem. But another problem generally is visa overstay. They are trying aggressively to ramp up information to determine those who have overstayed their visas and then start enforcement priority. So my advice to you, if you are here in this country and you have already overstayed, try to do something. The days of not doing anything is over. Do something. Try to look for something to fix your status. So they are ramping it up right now. So it's going to be, by the time they start the implementation, we are giving you this advance notice so that you don't wait until they start arresting people who overstay before you start doing something. Because as we have seen, the implementation of this administration has been very brutal. And now that we know that this is their next plan, so if you have overstayed, just find a way to do something. I mean, you can't just stay and not do anything and just expect that something will be okay. Try to do something. If you don't know what to do, I mean, go and consult with an attorney and find a way to fix your status. As far as the travel ban is concerned, I hope and pray that Nigeria will not allow it to affect them, because since they have given them 60 days notice, I believe that whatever they are asking for, the Nigerian government should be able to do it before the expiration of the 60 days. Because I know that even it's not going to be in the interest of the Nigerian government to have Nigeria banned, because there are a lot of Nigerians who are doing legitimate business with the United States government or in the US. So it's not going to be in the interest of Nigeria. But generally, if it affects Nigeria, then Nigerians will not be able to come in here while the travel ban is in operation. Next question, please.
Sir, my US girlfriend is in Texas while I'm in Delaware. What is your advice to us getting married and staying together in Texas? Yes, you can get married. The only thing is, if you are considering petition, if you are considering your U.S. citizen petitioning for you, you have to live together. You cannot live separately. If you are living in Delaware and she is in Texas, if you file, that would be problematic. But of course, before marriage, you can live together. But once you get, you can live separately before marriage. But once you get married, you have to live together and then show evidence that you are living together at the time you file the petition. But of course, you can date someone out of state. You can live separately while you are not married. But after marriage, especially before you file a petition, you have to have moved to Texas. Either you move to join her in Texas or she moved to join you in Delaware. The most important thing is that you live together at the time you file your petition. Next question, please. I'm a green card holder that was put in removal proceedings, but my case was dismissed without prejudice based on default NTA. I am qualified for 2007A1H waiver. Is he I am or am I? Is he asking a question? I'm trying to understand.
I am qualified.
Okay, I'm qualified. Okay. Is there anything I can do to bring my case back to court before my daughter turns 21? You see, this is a very, very, very delicate question. And I want you to treat the answer I'm going to give you delicately. As I always say, immigration is not a one-cap-fits-all. You see, 237A1H waiver, it means that for someone to qualify for 237A1H waiver, it means that you must have obtained your green card fraudulently. Now, what is the requirement? The requirement is that, 1, you must have obtained green card fraudulently. 2, you must have at least one U.S. citizen qualifying relative. This is one of the areas where it is different from every other waiver. Your U.S. citizen qualifying relative does not need to prove hardship. However, even though those are the 2 statutory requirements, there is still an element of discretion. The court still have discretionary authority in granting 237A1H waiver. And here is my concern, and that is why I am advising whoever sent this question to tread softly. Right now, you are not in removal proceedings. I understand that you are trying to protect your son before your son turns, or your daughter before your daughter turns 21. But what if you file a motion to reopen and then the 237A1H is not approved? What happens? You are going to be in problem. Because like I said, there is an element of discretion in that 237A1H waiver. You are not required to prove hardship to anyone. You only need to show 2 things. 1, you obtain the green card by fraud. 2, you have a U.S. citizen qualifying relative. Those are the statutory requirements. But my fear is the aspect of the discretion. Why am I saying this? As you probably already know, I've been away for more than 2 weeks now, out of the country. I just came back. I came back and I met some not very good news. I had some asylum cases. At least I had an asylum case that I did before I traveled, where the immigration judge granted the asylum. But guess what? I came back and I realized that the Trump administration, they filed an appeal. What does that mean? They disagree with the immigration judge. They filed an appeal. So the point I'm making here is that even what if the immigration judge granted your 237A1H waiver and then the government appealed? What if the judge denied it? So if you, under this administration, especially with what is going on right now, if you can avoid it, I will ask you to avoid it. That is what I will do if I'm in your shoes, based on what we see. I mean, I know that in the past, yes, there have been cases, although very rare, where government filed an appeal against immigration judges' decisions, but not in a case of what I considered a straightforward asylum case. This was an asylum that was based on fact and on document. It's not that the judge just decided I'm going to grant it. We went into full trial. We presented documentary evidence. We presented testimony. We presented uncontrovertible evidence. And then the judge granted it. But guess what? The government filed an appeal. So this is an unprecedented period. So if you are not in removal proceedings, if I am in your shoes, I will not bring myself back to court, because nothing under this administration, nothing is guaranteed under this administration. Next question, please. Hello, sir.
You already addressed that one.
Okay.
I've already responded to this one. Because you wanted to know about an appointment. That's it.
Okay.
Okay, this one.
Sir, please, how can you help dismiss my pending asylum immigration court case and resubmit another asylum application claim based on my wife's persecution claim? Well, if you're already in immigration proceedings, we can't just there's no way to just dismiss and refile. No, it doesn't work like that. However, based on what you have provided here, if you have a pending asylum case, if your wife has a legitimate basis to apply for asylum, let her go ahead. Well, I will need more information, because I don't know if your wife is also in removal proceedings. I don't know if your wife is a derivative under your own application. I don't know if you file your asylum within 1 year of entry, because even if you are talking about refiling, if you refile, remember, it's going to have today's date. So have you been in the US for more than 1 year? So if you withdraw one that was already pending and you refile a new one, if you are refiling that new one outside of the 1 year, that is going to be a legal ground to deny it if it was filed. So these things are not as straightforward as a lot of people think. So, but assuming that you are currently in removal proceedings and your wife is a derivative, is also in removal proceedings, you don't need to withdraw your own. Your wife can file a brand new application, and then you will find a way to ensure that your wife's application is the one that was first processed. So after your wife's application has been accepted as timely filed, you can now tell the court that you prefer to go with that application as opposed to your own application. But if you just attempt to withdraw your application and refile it, you may be creating a big problem for yourself that you may not be able to solve because of the 1 year deadline. So it's more complicated than that. Next question, please. I see it's already 1:50. You can look at the last question now and cut it off. Yeah. Yeah, you can cut the last question off from this moment. But let's keep going. Okay, yeah, welcome back, sir. We missed you. Thank you. I missed my people too. Okay, next question. I am an international student with EB1 approval and pending adjustment of status. If I can't find funding for the next fall, what should I do? as I won't be registering for courses next fall. If you already have a pending adjustment of status application, legally, you are not even an international student. This is one of those things that a lot of people don't know. International student status, F1 status, and I-485, they don't operate concurrently. They don't operate concurrently. Whenever you file adjustment of status, it automatically invalidates any F pending status. Adjustment of status is different from any other application. It is not the same if you file I-130. It is not the same if you file I-140. It is not the same if you file any non-immigrant status, change of status from one non-immigrant to another. It is not the same if you file asylum application. But once you file I-485, application for adjustment of status, it automatically invalidates every non-immigrant status that you may have. So based on this fact that you provided, you are not even an international student. So whether you register for course or you don't register for course, it is completely irrelevant to your legal status. It is the I-485 that is pending that determines your current status. So if you don't register, it's not going to affect anything. But I want to also believe that with your pending AOS, adjustment of status, you probably apply for employment authorization. So you can show the receipt notice, the I-485 receipt notice, and if you have EAD, both of them, you can show it to your international office or international student office to let them know that you are not on F1 status anymore. Because if you don't provide that information, the school may notify ICE, and ICE may terminate your civics, and you may be arrested. You may be a victim of immigration enforcement, despite the fact that you have a pending adjustment of status. Remember, if you don't tell the school is not going to know. And of course, if they don't know, if you don't register for fall, they may contact ICE, and then ICE can terminate your civics, and then you may be at risk of being arrested. So in order to avoid all of that, let the school know that you have a pending adjustment of status. Provide them with a copy of the I-485 receipt notice, copy of the I-140 EB1 approval notice, and if you have EAD, provide them a copy so that they don't go ahead and terminate your civics and you get into trouble. Next question, please. Well done, sir. Great competition in Nigeria. Oh, thank you. So this person must have followed our competition. Did you post it on our website? The channels, TV thing? Yes. Okay. Thank you. Sir, is it true if one gets H1B picked in lottery, but the employer doesn't want to go through with the job, the F1 student loses all status if no new job is found? I'm trying to understand this question. If you are currently on F1, your F1 status remains valid for as long as you are either in school or you are on OPT. But of course, if the H1B employer fails to go through with the H1B, then you will need to keep maintaining your F1 status, because if you don't, you will be out of status. You have to, if you have already graduated, let's say you are on OPT, maybe you need to go back and enroll for a master's program or do something. That you just have to keep yourself in status, because if the H1B employer doesn't follow through, then you will be out of status. Yes, that is very true. Next question, please. Good afternoon, sir. God bless you for all you do for people. Thank you. Please, is it safe for me to travel to Nigeria in July? I got my green card in October 2024. Of course, it is safe for you to travel. However, I can't give you a blanket green light without knowing more. Do you have any criminal issue? If you don't have anything, then there is nothing to worry about. Another one, how did you get your green card? Was it based on a marriage to a U.S. citizen? If yes, are you still in good relationship with your spouse? Are you still together? Those are questions you will need to answer before I can tell you whether everything will be smooth. But assuming that everything is okay, yes, if you don't have, majorly, it is criminal record that is the key. If you have criminal record, your green card may not prevent you from being detained when you return. When you return, if you have a criminal record, you are going to be treated as an arriving alien. And the law requires that an arriving alien be detained. It is mandatory detention. It is one of those few things where you cannot get a bond. So right from the airport, if they decide to detain you, you are not going to get a bond until you go through the removal proceedings. So your case is going to be a detained case. But if you don't have a criminal record, there's nothing to worry about. If you got your green card through marriage to a U.S. citizen, all you just need to do is to make sure that you put your house in order. If you are not in good relationship with your spouse, it is better to end the marriage than to leave it. I don't know how to explain this. You can't. It's either you are in or you are out. It's either you are married or you are not married. If you are married and the marriage is not working, end it. If you are married and the marriage is not working and you travel, if for any reason, upon your return, if the officer decides to call your spouse and ask questions, what if your spouse says something negative? So those are the dangers if you obtain your green card through marriage to a U.S. citizen. If your marriage is not in good condition, just end it. The law does not require that a marriage must work. The law only requires that you must enter the marriage in good faith. So if you already have your green card, if your marriage is not working, if you end it, the only thing you will need to prove is that at the time of your marriage was in good faith. Nobody is going to require you to prove that why your marriage didn't work. Everybody have marital issues. Even immigration officers themselves do go through marital problems. So even judges go through marital challenges. Nobody is immune from marital challenges. However, what you cannot do is to have it both ways. Is either you are in a marriage or you are not. So that would be my advice. Welcome back, Dr. Asekun. Congratulations on the program at OOU. More grace to you. Thank you. Good afternoon. I'm a document immigrant here in the U.S. Or does it mean documented immigrant? Okay. I'm a documented immigrant here in the U.S. and will be traveling locally in the U.S. I believe I can travel locally via airport with my EAD. Oh yes, your EAD is a valid document to travel with. Yes, I know that they've started enforcing the Real ID Act. That only requires that anyone has an ID or a driver license that has been verified, that they have verified your immigration status. That's what Real ID means. It simply means that the ID must have been issued after they have verified your immigration status in the U.S. So employment authorization, because it is a document issued by the government, by USCIS, that is a valid means of identification for local travel. Yes, you can travel with it. Next question, please. Sir, I have asylum pending and I have my EB2 approved. Can I proceed with my green card application when my date becomes current? Well, I don't know the full information. was the asylum filed before the expiration of the I-94? Because as I've said over and over and over, every employment-based petition requires that an applicant must be maintaining legal status at the time of application for permanent residence. So, since you entered the US up till the date that you apply for permanent residence, you must show evidence that you have been maintaining legal status. Because you have a pending asylum application does not automatically mean that you'll be eligible for EB2. It is only if you file your asylum before the expiration of your I-94. That is when that loophole can be utilized. That is the only time that you may be able to get your green card through EB. But if your I-94 has already expired before you file your asylum, then you will not be able to get green card through EB2, even though your petition has already been approved. It's unfortunate, that's the law. We can't change it. Next question, please. Good afternoon, sir. Thanks for what you do. Please, is it safe to travel to Nigeria with advanced parole at the moment and get admitted back to the US? Well, again, if you listen to what I've been saying, immigration is not a one-cap-fits-all. Every case is different. Number one, if you are granted advanced parole, there is a chance that you'll be able to travel and come back without any problem. However, there are multiple issues that I want you to consider. One, did you apply for your adjustment of status before the expiration of your I-94, or did you apply after the expiration of your I-94? Two, what was the basis of the application itself? Was this a family-based petition or was it employment-based petition? I mean, there are a lot of things that you have to consider. Three, if this was a family-based petition, if you are traveling, are you traveling with your United States spouse or are you traveling alone? Two, assuming you are traveling alone, what is the status of your relationship? In fact, as I was advising somebody who already got the green card, for someone who is traveling with the advanced parole, the probability that they will actually contact your spouse, if this is based on family petition, the probability that they will contact your spouse is much higher for someone who is traveling with advanced parole versus somebody who is traveling with a green card. With a green card, I would say the option is 50-50. They may call your spouse, they may not. But for someone traveling with advanced parole, if this is family-based, the probability that they will contact your spouse, I would say probably 70-30. So if all of these are in order, yes, you can travel. Actually, there is a case law that says that USCIS should not grant advanced parole if they believe that the applicant is not eligible to travel. And USCIS, to my knowledge, they have been implementing that case law for the past few years. I've seen a lot of advanced parole documents that were denied on the ground that the applicant is not eligible. So I know that they have been enforcing it. So to that extent, that will give me some level of confidence regarding anyone who has been granted advanced parole, because if USCIS believe that you are not eligible, they probably will not approve it. But having said that, it still does not take away the probability of contacting your spouse or the probability of even denying you admission upon entry. But this is not a one-cap-fits-all. Every case is different. So you have to look at the fact of your case. If you file it before the expiration of your I-94, if this is a family-based petition and you are living with your spouse, you don't have any issue, maybe when you are even traveling, maybe your spouse is the one that dropped you at the airport and he or she is the one that will pick you up upon your return. So I don't see any issue. But if your house is not in order, I will consider traveling. So that is what I will say in this. No, I mean I will reconsider. I will reconsider traveling. That's what I mean. Yeah, sorry. Yeah. Next question. I'm traveling to Nigeria. Do I need Nigerian visa? I'm a dual citizen. If you have a Nigerian passport, you don't need it. I mean, I've said this over and over during my podcast, and I just came back from Nigeria. When I was leaving, I gave them my Nigerian passport. They use it to check me in. In fact, when I was leaving, when I was checking in, I gave the agent, the airline agent, I travel with Delta Airline. I gave the airline agent my Nigerian passport. He returned it to me and said, oh, I need your American passport. I insisted that, look, I know I have American passport, but I want to check out with my Nigerian passport. No, it's the other way around, sorry. I gave them my American passport. They returned it to me. They requested my Nigerian passport. So I told the officer that I insisted that I needed to check in. I needed to be checked in with my American passport. So the agent tried to argue with me that, no, I don't need your American passport. I said, well, I'm the passenger here. I want you to enter my American passport as my document that I'm traveling with. He said, but you don't have a visa. Don't worry about that. When I get to Nigeria, I will deal with that. So reluctantly, the officer collected my American passport, entered it in, and then we left. So when I got to Nigeria, I gave them my Nigerian passport. The agent, the officer there said, oh, but it didn't show that you are a Nigerian. I said, well, that's because I checked in with my American passport. So I brought out my American passport. I showed it to him, and then he allowed me into Nigeria. So just make sure you check in with your American passport when you are leaving. And when you come back, there's no problem. And as I said, I came back yesterday. When I was coming in, I didn't even talk to any officer. I just went in front of a computer screen. He took my passport, my picture, and I went in. That's it. No questions asked. But if I had allowed the airline agent to check me in as a Nigerian, upon my return, they probably would have flagged me because it will show on their system that I'm a Nigerian. So they probably would have flagged me and then ask questions. Of course, I will still be able to show it. I'm a dual citizen. I will still be able to show my passport, but doing it the right way prevented any issue. So you can travel with you don't need a visa. You can travel. The next question. Good afternoon, attorney. Thanks for your assistance always. Thank you too. I have a pending withholding of removal asylum. I got married to a USA citizen and my application has been approved. What's the next step? Well, if you have a pending removal proceedings, once your application has been approved, so file Form I-485, you have to first file it with USCIS and get a receipt notice, and then do another copy and file it with the immigration court and request adjustment of status. USCIS will not have jurisdiction over your case because you are in removal proceedings. But once you file your adjustment of status with the court, and then you can now tell the court that you prefer to go with adjustment of status instead of pursuing your withholding of removal asylum claim. Next question, please. Good afternoon, sir. Thanks for what you are doing. Please, is it okay? I'm in Mexico. Okay, I'm in Mexico. Is it advisable to have lawyer in United States before entering at the border? I don't understand this. entering as how? Does this person have a visa? Or I don't understand.
Is it okay? I'm in Mexico. Is it advisable to have a lawyer in the United States before entering the border? So he wants to enter through Mexico.
Yeah, but what I'm trying to determine is it doesn't say whether he has a visa or anything. So is it trying to come in
Maybe apply for
to come and apply for asylum? Well, I would say yes. If you are planning to come in, if you don't already have an existing visa, if you don't already, if you are planning to come in through the border and apply for asylum, yes, I will suggest that it is advisable that you talk to an immigration lawyer, because the reason is very simple. What you believe may be a grant for asylum may actually not be a grant for asylum. So it is better to talk to an immigration lawyer and ask questions so that they explain to you the requirement of asylum. They explain to you what kind of documentation you will need to provide. Because if you are coming in through the border and you don't have a visa, you are probably going to be applying for asylum at the port of entry. And when you do that, like I said, one, you are going to be detained. Two, they are going to, because those CBP officers that are admitting you, they are not asylum officers. So they are going to schedule an appointment for you to talk to an asylum officer who will conduct what is called credible fear interview for you. And if you don't understand all these things before you go into it, it may be more difficult, because once you tell them something, you can't undo whatever you do. You can't untell them what you already told them. So it is better to have a clear understanding of what the requirement is and be sure that you will meet the requirement before you attempt crossing the border. Next question, please. Good day, sir. Can someone with a 2-year green card travel to Nigeria this period? Oh, yes. I mean, 2-year green card, it simply means that you got your green card through marriage to a U.S. citizen and your marriage is less than 2 years. For as long as you are in good relationship with your spouse and you are living together, your house is in order, you don't have any criminal record, yes, you can travel. Next question, please. My friend overstayed when she came to have a baby. Will that affect her when her son filed for her? Well, for her son to file for her, her son will have to be 21 years old. So if you are talking about somebody who overstayed, the question is when. If she overstayed 21 years ago, that's not an issue, because for overstay, the punishment is not that far. If someone overstay for a period of less than 180 days, 6 months, that is a grace period for the purpose of adjustment of status, for the purpose of U.S. citizen petitioning for immediate family. If someone overstay for more than 6 months but less than 1 year, that's a period of 3-year ban. So if someone overstay for a period of more than 1 year, that is a period of 10-year bar. And then if someone overstay for more than 1 year, left the United States, and then re-enter unlawfully or re-enter without a visa, that's a permanent bar. That one, there will be no solution for that. But in this case, based on this fact, if she only overstayed at the time she came to have a baby, for her baby to even petition for her, that means the baby must have been 21 years old. So the worst case scenario in this situation will be 10-year bar. So 10 years will have been long gone. But if this person is still in the US, since that time has never left, that's not going to be a problem for as long as the original entry was legal. It will not affect it. Next question, please. Good afternoon, Dr. Asekun. Thank you for the great work. Thank you. God bless you and your team. Amen. Sir, we applied for adjustment of status via EB1 7 weeks ago. We also applied for I-131 and 765 together. Please move it up. We received notice of approval for I-485 after 6 weeks. Green card received now, but nothing has happened on the I-765 application in which requested for Social Security for the kids. My question is if I should wait or approach Social Security office to apply for SSN for my children. Oh, you already have the green card. They are not going to approve the 765. Even if the 765 is to be adjudicated now, they will deny it because you already have the green card. So just go to the Social Security office with your green card and apply for Social Security number for your children, assuming that it has not been issued already. Sometimes, because Social Security is attached to 765, because your 765 has not been processed, it may not be issued. So the best thing is go to Social Security office and go and apply, and they will give it to you. But the 765 may not come. Next question, please.
Unless they requested it for the I-485, then
Yeah, it is also possible to request for the Social Security on the form I-485 itself. But even at that, since you already have the physical green card, the best thing is just go to Social Security office. If USCIS has requested it, Social Security will tell you, and they will still give it to you. If they have not requested it, they will tell you to submit a new application, and they will issue it. And the more important reason why it is even good to apply for it, to go to Social Security, is that even the Social Security that will come with the 765, it is the Social Security that will have limitation on it. They will write on it, valid for employment with DHS authorization only. So, but with the green card, the Social Security, it will be the same number, but it will not have those limitations. So just go to Social Security office and apply for one. Next question. No, have I mentioned that? No. Yeah. Good afternoon. What do you think on the government flip-flop with pausing and unpausing rates? Also rumors saying ICE is out of fund. Will things go back to normal soon? Well, anyone who is following President Donald Trump administration, you will know that the president, unfortunately, in my opinion, is not a stable person. He's not somebody who is principled. I mean, we've seen lots and lots and lots of inconsistencies. I mean, look at what happened with the trade deals. Today, we impose 50% tariff. Tomorrow, they will suspend it. The next tomorrow, they will do this. I mean, I think, in my opinion, the president is somebody who is influenced by outside opinions. Most of the time, he will act, and then when there is pressure, he will give up. That is what I believe is happening. I mean, I won't say he doesn't have a mind of his own, but I think he's somebody who is easily influenced by other people's opinion. Even during his first term, I remember there were so many things that he did. I mean, he will say that, he will grant DACA, and then the hardcore Republicans will put pressure. Then he will say, I'm not going to do it again. Even I listened to his press conference today. I will intervene in Iran. Maybe I will, maybe I will not. I mean, he's not, I don't know. Maybe he's doing this intentionally. Who knows? I don't know. I'm not a mind reader. I really don't know why he's doing it. But the truth of the matter is that all this flip-flopping, I really don't know how to explain it. Today they will say this, tomorrow they will do something else. Next tomorrow they will say something. He will say he will not do certain things, and then you will see him do it. Then he will say he will do certain things, then you will see him not doing it. So I really don't know. Honestly, I can't guarantee that anything will go back to normal under this president. I mean, with everything going on right now, if the administration is still talking about visa overstay, they are still ramping up. Let me say this. I'm a Yoruba man from Nigeria. In Yoruba land, there is a proverb that says that you use the king's name to cut an Iroko tree. Many of these things may actually not be from the president, but people who are only using his name to carry it out. I mean, I don't see the president doing many of these things that he is supposedly doing. But when you are looking at his administration, anyone who is part of the administration, whatever step they take, it is the president that is responsible for it. So I believe that many of these things they are doing, the president probably didn't know about it. Because if you look at the update today, especially looking at these farm and hotel workers, it was the president himself who said that, you know what, we are going to look at all these farm workers because they know that there is a lot of shortage when it comes to farm workers. So it was the president that said it. And then now, ELA is telling us that, ELA is American Immigration Lawyers Association, they are telling us that, oh, there is a pressure from the White House. So the question is, who is the one giving pressure? Is it the president that is pressurizing himself, or is it the people who are working in the White House who is giving pressure to DHS? Which I believe is actually what is going on. I mean, we all know those who are in the White House. Stephen Miller, is that his name? Is it Steve Miller or Stephen Miller? The White House immigration person, not the czar. The czar is not in the White House. The czar is the one doing the. But that Stephen Miller guy is the most anti-immigration human being that I've ever known, and is currently in the White House. Is it Stephen or Steve? Stephen Miller. So when they say there is a pressure from the White House, I don't think it's actually pressure from the president. I think it is pressure from those who are using the president's name to do all these things. But unfortunately, I really can't predict when anything will, or if anything, will ever go back to normal. God will help us. Next question, please. Oh, Dr. Asekun, welcome back. Thank you. Next one. Okay. Thank you for your support service. I have filed for asylum and have my work authorization from last year, though in school, and you advise an overstay visa. I want to ask which change of status. I don't understand. What status will be appropriate, sir? Can you help me with the question? I don't understand it. Let me read it again. I don't understand the question.
Are they asking? Okay.
It says I apply for asylum and I have my work authorization from last year. That is very clear. Though in school, and you advise an overstay visa. So what does that mean? I want to ask which change of status.
Are they asking, should they change to a student status instead of maybe doing the asylum with the work?
I honestly don't understand the question. I don't. Well, if the writer is still on this podcast, you can clarify it. I honestly don't understand the question, and it will be difficult to answer a question that I don't understand. I see that you apply for asylum, you have work authorization, then from there, I don't understand any other thing after that. So what exactly is the question? Are you trying to change? I mean, I can't just guess. I don't understand. Go to the next question, please. If my T visa is approved with misrepresentation and IWI waiver, can I use that waiver for family adjustment of status via my U.S. citizen child? Oh, if T visa is approved, the T visa itself can be used to apply for adjustment of status. You don't even need your U.S. citizen child for that. I mean, if your T visa is approved, T visa is for victim of trafficking. So if they approve it, you can use that approval to apply for adjustment of status. And that will even be your best bet, because if you try to apply for adjustment of status through your child, then you will need to prove legal entry. But with the T visa, they will waive your EWI entry. So it's better to just use your T visa to apply for adjustment of status. Next question. You are welcome back, sir. How was your trip? Well, we thank God. Everything was okay. How was your program in Nigeria, my state? Ogun, God bless you. Oh, thank you. I think we posted a clip of the program on our YouTube channel.
Yeah, YouTube, Instagram.
Yes, so it was a nice program. We thank God. Okay. Good day, sir. Is that a next question, or is it from the same person?
This is a different one. I don't think.
Oh, okay. I think that was just a comment. Okay.
I think so.
Yeah, thank you. Good day, sir. My I-130 just got approved with a new EAD C31. What does this status stand for, and how long is it going to take for me to get a green card? I-130 does not come with EAD. I think there's something that is missing from this question. I-130 is a petition. The title is Petition for Alien Relative. So when it is approved,
And C31 is VAWA.
so they can't approve I-130 and maybe this person is just, maybe they misunderstand maybe they want to talk about I-360. Yeah, because I-130 does not come with EAD.
Exactly.
So I-130 does not come with EAD. But let's assume this person is talking about VAWA. What's the question? Just got assuming it's VAWA approved with a new EAD. What does it stand for, and how long is it going to take for me to get a green card? Well, if your VAWA has been approved, you can get your green card any moment from now, for as long as they don't have any updated request. For example, if your medical has not expired, they can send you your green card without additional interview. But if your medical has expired, you may receive a request for evidence asking you to provide updated medicals. And then they can either invite you for interview for the VAWA or just approve the green card. Usually, after the approval, it takes an average of maybe 90 days. I would say 90 days, 3 to 6 months average after the approval of the VAWA. But this question is not correct, because I-130 is not the same thing as VAWA. Yeah, maybe he was talking about I-360. So next question, please. Yeah. Good day, sir. If one is having a pending I-751, that is removal of condition, and citizenship, and want to travel abroad, is it advisable to go in this era? Oh yes, this has nothing to do with traveling. As far as traveling is concerned, what determines whether one should travel or not is, one, criminal record. Do you have any criminal record? Even if you have not been convicted, do you have any criminal arrest? If you have been in trouble with the law, I will advise you to avoid traveling. But if you have not, it doesn't stop anything. Then the 751, I'm assuming this is based on a marriage to a U.S. citizen, because 751 simply means removal of condition based on a 2-year green card. So this must be based on a marriage to a U.S. citizen. So another thing you want to ensure, you have to be sure that your marriage is in order. You are not having any issue with your spouse, because if you travel and you want to come back and then they contact your spouse, if your spouse, I've seen a situation where they call somebody was coming in from abroad, and then the officer just asked, oh, where have you been? Oh, when did you travel? When are you, how long were you away? And then they called the spouse. Where's your husband? Oh, he said, my husband is at home. Oh, he's at work. The husband who has been away for some weeks. So that really raised a lot of doubt about the relationship. That will create a major problem. So my advice.
We've been going for so long that the battery died.
Okay. So my advice is that you just make sure that your house is in order. Is it possible to plug it while we are?
I can move this one over.
Okay, is it this one that is?
Yeah, this one's still on, but
Okay.
we're about to round up. The next
Is that
one's
the last question?
one. The next one is the last one.
Okay.
Yeah.
Well, we've been on this podcast for so long, and some of the batteries are giving us signs that the battery is about to die. So,
That one died. That one's dead.
oh, one is dead already. Okay. So, hopefully, we will be rounding up very shortly. Next question.
Okay. Creepy. There.
Okay.
Oh, let me see if I can move it because you can't look and I see.
But on the phone here, I can still see, I've not seen any changes.
It'll change in a second.
Okay.
Okay. We're just gonna go right there for now.
Okay. Let's just
Okay, yeah, it came up.
few more questions.
This last
Next, okay, that's the last one.
This one, yeah.
Okay. Greetings, sir. I just completed my master's program and started my OPT this month. What options do I have to adjust my status? Can my brother in the U.S. Marine file for me with my family in Nigeria? Starting from the last question, no, your brother can file a petition on your behalf, but his petition cannot keep you in status, or neither can it bring your family. This is because immigration law does not recognize siblings as part of immigration law does not consider siblings as immediate family. Siblings are considered extended family member. Siblings are considered extended family member. So for that reason, your brother's petition will not be able to keep you in status. Now, as for what your options are, this is an open-ended question. I don't see how we can answer that during a live podcast, because this is a question that can take 1 hour to answer. So I will request that you schedule a consultation appointment to do that. So any other question after this?
No, that's it. That's the last one.
That's the last one. Okay, again, I want to apologize for our absence in the last couple of weeks. I traveled out of the country. I just returned. For those who sent messages, some people were genuinely concerned, worried about me. Nothing happened to me. I'm fine. I just traveled out of the country. I'm back now, and by God's grace, our podcast will continue. I'm hale and hearty. Thank you for all the show of support. It is very, very encouraging. At least I know that I do have a family that cares about me. I want you to know that I appreciate it. I appreciate all the email messages, text messages to the office. I even understand that some people visited the office physically to be sure that everything is okay. I really want you to know that I sincerely appreciate it. And I apologize for not even giving advance notice that I would not be around during that period. It was an oversight. So I want you to know that we do appreciate you. We appreciate all the feedback, and we will continue to try our best. In the meantime, we know that the situation we are in currently is very, very worrisome. But at the same time, I know that with God, all things are possible. God will find a way to protect every one of us. Just try as much as possible to avoid trouble, stay out of trouble, and remember to follow us on all our other social media platforms. I hope to see you again next week. Until then, God bless you. I remain Dr. Olu Asekun.